Well, once your appeal is lost and your request for a rehearing is also lost, there are other post-conviction motions that can be made. In Florida, typically they have a couple of post-conviction motions that people avail themselves of. First one is called a 3800 3.800, and that post-conviction motion is to correct any illegalities about the sentence. In other words, if the judge scored your sheet wrong and gave you a sentence outside of the statutory maximum, if you were classified as a prison release reoffender when you shouldn't have been, or a habitual offender, which you shouldn't have been, these are errors that can be filed at any time because those are illegal sentences if you prevail. The most common type of post-conviction motion in Florida is called a 3850 or a 3.850. Typically, that motion is filed to challenge the effectiveness or competency of your trial attorney in representing you at the trial, so that if your lawyer wasn't properly prepared, didn't do the proper investigation, didn't understand the issues properly, didn't argue the proper points, didn't know how to cross-examine the expert witnesses. There are all kinds of things that the trial lawyer is obligated to do, a competent one, and if they fall down in doing those tasks, you've got a potential for relief claiming that your counsel was ineffective and you didn't have a fair trial, which is guaranteed to you under the Constitution. So there's a two-pronged test for this motion that has to be satisfied to prevail. First, you have to show that there was error, that's agreed error, and it was improper for the lawyer to do or not do a particular thing. The tougher element to prove to succeed in that motion is to prove that actual prejudice occurred. In other words, had your lawyer done what he should have done, would the result have been different to your benefit? This is very speculative, so it's not as easy to prove. You can always prove the lawyer made a mistake, but just making a mistake is not enough to prevail on a 3.850. There has to be actual prejudice to your case that you can show that the lawyer's incompetence had occurred. And that is something you have to convince the trial court judge of. You go back to the same trial judge that convicted you to ask for this relief.